Hi everybody, it's Honest John again. Now, on September 7th, 2010, Remington Arms released a statement entitled, "A Safe, Trusted, Reliable Rifle." In that statement, they said that reports of problems with its Walker trigger mechanism on the Remington 700 rifle were baseless, unproven, and that it is free of any defect. This statement was made in response to the discovery that there were lawsuits that had been settled by Remington because of defects in the trigger mechanism, which had resulted in several injuries and deaths. The statement was not made under oath. When Remington executives testified in court under penalty of perjury, a different picture emerged. Internal documents revealed that for decades, Remington executives were aware that the trigger mechanism of the 700 rifle was defective, and that it would from time to time fire when the safety was off without anyone pulling the trigger. Remington settled several lawsuits over deaths and injuries caused by this defect in that 700 rifle. But they never recalled the product, and they never informed the public. As a matter of fact, Remington is still selling the 700 rifle with the defective trigger mechanism. So how did they keep this a secret for so long? Well, confidentiality agreements. Every settlement had one. The plaintiffs agreed to them, and the judges allowed them, even though they knew that the rifles posed a threat to anyone who bought them or anyone who was near the people who bought them. I understand that there may be times when plaintiffs and defendants might want to protect their privacy in a settlement. In a divorce case, for example, where personal and embarrassing information might be disclosed. But when there is a threat to public safety, it is completely unethical for judges to allow that threat to remain a secret. Unfortunately, this is all too common. Over the years, the Catholic Church kept its problem with child molesting priests a secret using confidential settlements. Automakers and other business have done the same thing. And as a result, it often takes years for the public to be made aware of defects in products that can seriously injure or even kill them. Now, you would think that it would not be necessary to force the courts to warn the public when they are in danger, that any judge with a scrap of conscience would refuse to allow our safety to be compromised. But that's just not the way the system works. So what is needed is legislation forbidding confidential settlements in cases affecting public safety. But that means going against the fat cats, who will spend a lot of money against it. Because whether it's a car maker, or a gun manufacturer, or a church, the most important thing is profit. Thanks for listening.